rule of law, land power, and civil authority, a professional legal opinion on the Abuja FCT minister and naval officer confrontation. My fellow Nigerians, this is Charles Chukwumankwoka Esquire, a property and commercial lawyer based in Lagos, Nigeria. Today, I am giving a professional, independent legal opinion on the confrontation between the Honourable Minister of the Federal Capital Territory, Abuja, and the naval officer at a disputed land site in Gaduwa District in Abuja. The land in question is said to be plot 1946 Gaduwa District, Abuja, linked in media to Awa Zubaru Gamba, a retired vice admiral. This is a public education message. Please take note. A professional analysis and a call for order, discipline, and respect for rule of law. So you need to understand what this video presentation is. I've reviewed the available public records, including those from Premium Times, BBC News, TVC News, Sahara Reports, and others regarding the incident. The following is my expert opinion from a property law, administrative law, and public governance perspective. Facts as reported in this matter. I want to walk you through the facts as reported. Number one, the confrontation took place at a site, plot 1946, Gaduwa District, Abuja, which the FCT minister and officials were there presently and confronting the soldiers, asking for building approval and administration title. Two, the site is reported to be connected to the retired Chief of Naval Staff, Vice Admiral Awa Zubaru Gambo, and the military in some ways. Three, a uniform officer identified in the media as Lieutenant A.M. Yarewa and similarly alleged he was acting under the instruction from their superior. The fourth fact, the FCT minister demanded production of documents from the military personnel. The officer refused to yield or show proof at the time of the confrontation. The fifth fact, emotions ran high. The minister used strong language. You are very big fool, UTC, towards the officer. The sixth fact, this incident has sparked national debate among land governors in Abuja. The use of military personnel to guard property and the rule of law versus force or extra legal influence. You can see the controversy in the society now, in the media. Legal issues. Now, let me walk you through the legal issues in this issue. Several key legal and governance issues arise from the facts as stated below. Number one, authority of the FCT administration, that is FCTA, and enforcement power under the laws applicable to the administration in the Federal Capital Territory. The Federal Capital Territory Administration and its urban planning agencies is responsible for monitoring and controlling land allocations, ensuring building approvals, preventing encroachment and unapproved development. If a plot is indeed being developed without valid title documents or building approvals, the FCTA is within its legal rights to intervene, issue stop work orders, and where justified, enforce demolition or reclamation of government land. The incident suggests the FCT minister attempted to access the site for enforcement and demanded documents on the spot. That aligns with his statutory remit. Title to the land allocation process and chain of title. If the plot in question falls under green area, park, recreation, and other reserved land, as some media suggested, rather than legitimately allocated for private development, then the purported developer does not have claim title and approval for such development. That's position of law. In such case, any development is irregular, potentially subject to revocation, cancellation, and enforcement. Conversely, if the military/allocation side can demonstrate lawful allocation, valid title, and as well as building approval, then the FCTA must respect that and act within its legal framework, including giving notice, obtaining court order if required. The burden of proof of validity falls on the purported allottee once being challenged. Note the use of military personnel in land disputes / private property protection is not advisable. The presence of uniformed soldiers, naval officers to guard or block enforcement by the Federal Capital Authority raises concern. Generally, military personnel are not deployed to guard private property or land disputes unless under lawful order. Use of military force or appearance thereof in any property dispute could breach administrative law principles of equity before the law, the rule of law, and the creation of impunity. If the military or a former service chief uses his former position to secure the state security backing for private development that is legally and ethically problematic, respect for institutional boundaries, civility, and rule of law is another concern. The minister, as a senior public officer, must demonstrate respect for persons and institutions, uphold the dignity of office, and avoid inflammatory languages. Use of insult toward a military officer in uniform undermines public confidence and may amount to misconduct. Even if the minister felt justified, that's a bad one. On the other hand, a military officer must adhere to chain of command, cannot use orders as blockades, defense if those orders violate the law, must respect civil authority in administrative matter. Take note. Due process and court order must be observed. If there is a dispute over the title or allocation, the proper route is for the parties to resort to adjudication, either administrative review or litigation. The FCTA may issue notices, serve the allottee, or if necessary, obtain court order for demolition and revocation. The minister's approach must comply with those steps to avoid being arbitrary. If the military or the allottee claim lawful allocation, they must show title deed, approval, and chain of ownership, payment, etc. If not, then the FCT must act, but stay within procedural safeguards, equality, and non-arbitrariness. Note, all persons, including retired service chiefs and military officers, must submit to the same standard of land law as an ordinary citizen. If special privileges or bypassing of procedural process occur, then illegality and corruption may be present. My expert opinion on this: what is legal, what is not, what must be condemned from property law perspective. The following conclusion can be drawn, all right? So you get to understand. What appears legal or justified? Let me walk you through this. What appears legal or justified? The FCT minister's role in inspecting land allocations, questioning development approvals, and enforcing compliance within land use and planning law is entirely within his mandate. Him insisting on documentation is proper. If the plot is indeed a reserved green area or park or recreation land, as some reported on the media, then any attempt at converting to multipurpose development without due process is unlawful. Take note of this. So military will not use power to do that. What appears problematic or illegal here is: 1, the deployment of military personnel in uniform to a land dispute scene to block enforcement appears improper unless there is a clear lawful mandate to court order or a formal security order, which I don't think so. It risks misuse of state coercive power for private interests. If a retired chief of naval staff or his associates obtain land through altering reserved land designated for public purpose, using influences to bypass building approvals, or employing military men to resist enforcement, this is a serious breach of land law, administrative fairness, and public interest. The minister's conduct through enforcement is warranted. Addressing a uniform officer with insult undermines civil-military relations, decorum of office, and may hamper institutional cooperation. What is wrong and must be condemned, I must tell you. Number 1 is use of force or intimidation. Uniformed soldier blocking bulldozers in a civil property dispute must be absolutely condemned. This undermines rule of law, creates precedent of might over rights. Think about it. Land grabbing, especially by powerful individuals or retired service chiefs through misuse of public land or reserved land or bypassing planning approval, must be strongly condemned. The perpetrators need to be brought to justice. Corruption is not allowed. Public confidence in the market is being jeopardized. Note, any attempt by government officials or their agents to act arbitrarily, personally, or with insufficient process must be condemned. Enforcement must be fair, transparent, documented, and subject to the rule of law. Recommendation and guidance. I recommend the following. 1. I recommend immediate formal independent investigation. Example, FCT, Land Use Development Department, to look into the allocation and building approval status of plot 194/6, Gaduwa District. All relevant documents by the military or allotee side by side must be produced publicly. Allocation letter, certificate of occupancy, building permits must be produced to the public. All the payment receipt, everything, show the evidence that you own the land, show it to the public. If the title and approval are absent, the FCTA must issue a lawful notice of revocation or stop work order, comply with procedural fairness, must serve notice, allow representation, and if required, obtain court order for demolition rather than unilateral action, like we are disgracing ourselves there. Military authorities should clarify the basis for deployment of personnel to the site. For maintenance of discipline, the armed forces must avoid involvement in private property dispute unless it's lawfully authorized. The FCT minister should issue an apology for any unbecoming language towards military personnel while maintaining his enforcement stance. Very important, and I recommend this. Institutional cooperation cannot be sacrificed for ego. Forget your ego, forget your power. Moving forward, there must be clear guidelines. 1. Reserved land must be audited. Any development on such land must follow transparent allocation. Citizens, including ex-service chiefs, must not receive preferential treatment. That's corruption. Enforcement should be predictable, equitable, and rule-based. Final word. In my own capacity as a property law expert, it is clear that while enforcement of land use law in the FCT is essential and laudable, the situation as reported reveals significant governance lapses. The missing of military force with civil land regulation, possible irregular land allocation or change of use, the breakdown of respect between civilian officials and uniformed personnel, and the specter of impunity for the powerful. I firmly condemn any use of military uniform and armed personnel to shed private development from lawful regulatory oversight. I also condemn any behavior by the public official that disrespects institutional boundaries or employs intimidation, even if motivated by legitimate enforcement. It's not advisable at all. The rule of law must prevail, not the rule of might. All actors, government officials, military personnel, retired service chiefs, property developers must submit to the same legal process that every Nigerian citizen must subject to. Nigeria's property sector, the integrity of its land markets, and public confidence in governance depends on this. Should the investigation reveal that the development is unlawful, then the full weight of revocation and enforcement must follow with transparency and accountability, not that tomorrow they will close it behind the scene. Equally, if valid title and approval exist, the FCTA must respect the law and facilitate fairness rather than creating needless confrontation. I urge that this matter not be allowed to remain a spectacle, but be turned into a precedent for strengthening property rights, enforcing planning laws, and upholding equality before the law in the Federal Capital Territory. Respectfully, I submitted this opinion. It's my humble, personal opinion as Charles Chukwumakwoka, Esquire, a property lawyer based in Lagos, Nigeria. I want you to share your comments. Drop your comment on the comment section. Let's interact. What do you think about the whole thing? Do you feel that FCT minister did his best, or he ought to have done it better? Drop your comment on the comment section. On the other side, do you think that deploying the military officers to the sites, to a private property site, to safeguard the private property, do you feel is right? What's your opinion? Drop your comment on the comment section. Let's interact. This is my simple opinion as a property lawyer